All rise. The First District Court of Appeals is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. You may be seated. Good morning again. We have two cases on the docket this morning, and we will take them in the order in which they appear. The first case is Sylvia versus Castle Key Insurance Company. And counsel for the appellant, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, I'd like to reserve 10 minutes for rebuttal, if I may. That's okay. All right. Your Honors, the issue in this case, let me stop for a second. My name is Stephanie Taylor, and I'm appearing on behalf of the appellant, the plaintiff below, who is Joseph Sylvia. The issue presented in this case is, did the appellee, Castle Key Insurance Company, waive its right to appraisal under the insurance contract by defending this case on the merits by filing an answer with affirmative defenses and requesting a jury trial and responding extensively to discovery without ever in any of those pleadings or the discovery request appraisal, file a defense saying appraisal is due. An appraisal was not requested until after all of those were done and after they requested from us a settlement demand, which, by the way, a monetary number was never given in that settlement demand. We just gave them additional information. Another way to word the issue is, did the court below err in granting Castle Key's motion for reconsideration on their motion to invoke appraisal? And we feel yes, in both cases, the court below did err in that and relied on the cases from this district, Wooden and Norton, that are inapposite and do not apply to these circumstances. So this case arises from Hurricane Michael. Mr. Sylvia suffered damage. Some trees fell on his house, other structural damage. That damage was investigated by Castle Key early on at the end of 2018, and some monies were paid on that. Throughout the next year and a half, and this is seen in the discovery responses, so you'll know where this information is, and it's on page 153, for example, of
Counsel, so you're going to concede the statements in the discovery that are in the appendix as those are the facts that we're dealing with? Because I didn't see anything that was putting any of those facts in dispute. Right.
We're conceding that the facts are not in dispute, except, well, the only thing I would say that could be in dispute and is not, the document itself is not in the record, is one of the, of Castle Key's position is that they did not have enough information until we gave them a monetary demand. As I make clear when I am arguing before the court, we never gave them a monetary demand. There was never an amount. They had requested some information. We had an estimate that had been prepared by one of our experts, which we forwarded it, but we never requested an amount at all in that letter that was forwarded.
One of those, that is referenced in the discovery, this estimate?
That's, it's not referenced in discovery. It's referenced in the transcript from the hearing below.
Right, and that's a statement from counsel, though. I mean,
Well,
there's
correct.
no testimony about it.
Well, and exactly, Your Honor, whether or not there was ever an actual demand as well is all just statement from counsel.
But you'll also acknowledge that the insurance policy, which is actually not in the record either, has that appraisal provision in it?
Yes, Your Honor, it does. And we are not disputing at all that there are instances in this case, there is a contractual right to appraisal. But our position is that was waived by several of Castle Key's actions in the underlying case.
Is it a right or an obligation?
It's a right. We don't believe it's an obligation. Either party can request it. They're not obliged to do so. It says they can, and I believe it's on the record on page 69. Defendant does correctly cite what that provision of the policy says, indicating that it's a right if there is a dispute as to amount of loss. And I don't think any court has ever found that it's an obligation unless it has been demanded correctly, and then the other side is obliged to appraisal if it is so requested. But if not, it's waived.
And what happens with in your view, so if, let's say the appraisal process actually did go forward at some point.
Yes.
What happens at the end of that? Like when you get a number from either the two appraisers or an appraiser and the umpire agree, whatever?
Your Honor, that depends on when it was requested and the actions before that. For example, if there had been a civil remedy notice filed previous thereto and a lawsuit had been filed and had been stayed, often what will happen is it will go to appraisal, and then it will come back to the court to determine if there are fees due, interest due, and costs due. If it's requested before litigation, and sometimes after litigation, early on like it should be, it has to be raised in the initial pleading. Not a motion for a more definitive statement, but it must be raised in the first responsive pleading.
Where do you get that from?
There are
that
several
idea?
cases, but Johnson versus Nationwide is the primary case. Bronco talks about that. Several of the cases, Salducas, I believe, Your Honor.
Right, but in the context of appraisals or in the context of arbitration?
Well, some of them refer to it as appraisal and some in arbitration. But
Actually, most refer to it as arbitration, and in taking steps in litigation to actually litigate a case clearly is inconsistent with arbitration, because arbitration is an alternative to litigation. But my question is, and I'll cut to, here's where I'm really going with it, is appraisals are different, because there's not an adjudication. You still have to do something with that number, and it can presumably be a breach of contract in some way if the parties don't honor the appraisal pursuant to the insurance provision. What is it about just answering a complaint and litigating for what was this, like 5 months before? I mean, from
About 5 months,
filing
Your Honor.
until the
Yes, sir.
demand. What is it about the initial actions of the insurance company that is inconsistent with the idea of seeking an appraisal?
And first, Your Honor, I would disagree that an appraisal is an adjudication. You cannot get the appraisal overturned. Those numbers stand as if the same for an arbitration.
Sure, but you can't file it as a lien. You can't get it confirmed. You still have to do something in court and get a judgment on it, which is
that's
different
true,
than
Your
an
Honor.
arbitration.
We do have to move to get it confirmed if they do not pay that. And I honestly don't know in an arbitration if the people didn't pay under arbitration, if that would be the same. They may also have to get it confirmed. I don't know the answer, but it may be. But Your Honor, here's what happens is when somebody files an answer to a complaint and they defend on the merits, on the justice, what's included in the cause of action, and they defend, make defenses on that cause of action on the underlying case, they're waiving their right to appraisal because they're taking a position inconsistent with it knowingly and intentionally by not waiving it. The line of cases is clear on that. All the cases in Florida say that if you don't raise that, then you're waiving it.
Well, I mean, you're sort of equating it to a statute of limitations to me, where you have to raise it in the first responsive pleading or it's waived. But in this context, quite often, and you'll see this flowing throughout these cases, you don't have a specific or concise complaint with respect to damages, and that's understandable. You still have discovery to go through. So when you have somewhat of an ambiguous or broad allegation in a complaint, don't you think there's a problem with triggering that duty in the form of an answer to raise appraisal immediately or waive it when, quite frankly, you may have still questions about, do we have a coverage issue, or are we just disputing the amount of damages?
Your Honor, I don't think it's a problem because if there is an ambiguity in the complaint, you don't have to file a responsive pleading. You're not going to subject yourself to a default. what the defense can do and should have done in this case if there was a concern, but there wasn't. It was clear what we were
Well,
pleading.
and I think your case is distinguishable from the other cases, because
Yes.
I look back at you actually had quite a specific, in my opinion, complaint. In fact, you said, refused to timely provide adequate compensation for plaintiffs' covered losses.
And that is
So-
all we pled.
And I thought that was pretty specific as in compared to, Norton and Wooden, et cetera. So I think, would that have put them on notice adequately that this is not a coverage issue, this is a damages?
And Your Honor, it did put them on notice adequately because they responded. They filed an answer. And to that particular count, or not count, but that particular paragraph, they denied that. Then they filed affirmative defenses in regard to damages. So they understood our complaint. This wasn't a case where they needed to file a motion for a more definite statement. They understood what we were saying, or at least acted like they did.
Do you think that's complemented by, for example, interrogatory answers 5 and 6?
I do. And you can see, particularly in 5 and 6, where they continue to adjust the claim, and at the very end, there was an issue about windows. Mr. Sylvia was claiming money for windows. The defendant, Castle Key, did not pay that and essentially said it wasn't causally related, if you will. And so they knew at that point that we were claiming something, Mr. Sylvia, that they weren't paying. And they had already, by the time we filed suit, had 2 years to fully investigate and adjust the claim. They knew there was some amount outstanding. There's no requirement that they have to know the specific amount. And sometimes people may not know, because if they're not paying because of causation, in this case, they're saying the windows aren't caused, there's no requirements that we give them a settlement demand of a specific amount. And in fact, this case, we never did. So I don't think they can even use that as a defense here to support their position, because no settlement amount was ever asked for, and that's not the case law here. It was ripe for appraisal well before we filed suit. We're not saying that they couldn't have requested it after we filed suit, but in their first responsive pleading, which would have been an answer they needed to. Now, if they had done a motion for a more definitive statement because it was ambiguous, as happened in Wooden and Norton, that would have been okay. That's not a responsive pleading. But
So, for clarification though, is it your argument that it's waived because it wasn't raised in the first responsive complaint, period? Or in the alternative, if we don't accept that argument, it certainly was waived based on their conduct post-filing of the answer?
Your Honor, it's in the alternative because the underlying cases say you look at the totality of the circumstances, not just the length of time of litigation, not just what was filed, but is the action they're taking inconsistent with their right to appraisal? And all of those actions they took, Your Honor, are inconsistent. Filing an answer that never waives appraisal. They knew we were asking for additional compensation. At that point, they had already investigated the claim and adjusted the claim. They knew that if they wanted to go to appraisal, we're talking about amount here, which amount of loss is what the contract says is appropriate for appraisal. And yet still they did not request it. Rather, they defended on the merits with an answer. And they requested a jury trial. I mean, that is one of the most striking inconsistencies I can find. If you are requesting a jury trial, you're certainly not wanting an appraisal. And in the complaint, again, it was purely on compensation, which is the amount of loss, which also includes the cause of the loss, which was really the main issue here, underlying where they denied the coverage for the windows.
Counsel, before you sit down, I did want to ask you about your motion for prevailing party fees, assuming we get to that, and assuming we do find that you are the prevailing party. You cite to section 627.428. However, this court has recently concluded that section does not authorize prevailing party fees for interlocutory appeals. I don't know if you're familiar with that case, and if you are able to distinguish it in any way.
I am unprepared to answer your question. I have to admit that, and I apologize, Your Honor. I am not, but if there is any opportunity, if we do happen to win the appeal, we will certainly amend that, and if there's another appropriate case or statute to rely on, we will do so.
Okay, thank you,
Thank you.
counsel.
Good morning, Your Honors. I'm Jerry Sanders. I represent the defendant Castle Key Insurance Company appellee in this matter. The first question I wanted to answer was of Judge Tenenbaum, and that was why the demand that we're talking about that came on January 7th, 2021, was not put into evidence. It was styled a confidential correspondence in settlement negotiations, and so in order not to initiate litigation or to be a party to extensive litigation and not to have violated that provision of settlement negotiations, we couldn't put it into evidence, so we didn't put it into evidence. But I had to mention the fact that that's when we first got a demand and knew what it was about in our motion for reconsideration, obviously, or in motion to enforce appraisal. And so it's a fact. It's not disputed. Counsel argued it. It's certainly not a factual issue. I don't think there's a factual issue involved, that that's the first time we got a demand or knew that there was a dispute, actually. As was cited in my brief, there was no indication to Castle Key, and it hasn't been refuted by counsel, that there was a dispute concerning the initial adjustment of the claim at all. No demand letter, no letter of dispute from the insured, from anybody, until suit was filed. So we filed a simple answer, and then we were requested to respond to discovery, and which made sense to us, because perhaps counsel didn't know that it had been adjusted previously, because perhaps the insured was mistaken about the adjustment that was previous of the claim.
But you knew that the complaint was claiming the amount of loss, or it was, the suit was based on what they contend with. We weren't paid our covered losses. And if that's the case, why demand a jury trial as opposed to demanding the appraisal at that point?
I don't think it is that clear. I'm sorry. That's not, our interpretation was, well, perhaps counsel was mistaken. Perhaps I didn't understand that this had already been adjusted, this claim had been adjusted. It's really vague language, in my opinion, in the complaint. There wasn't any monetary demand in it, as you know. It's just you breached your contract and you didn't pay the claim. That's essentially what it's saying. And so we said, well, maybe they do need discovery. Maybe they do need to see that we actually have paid this claim previously to understand it. And I did start right away asking for a demand, or what was in dispute. Well, have you got a demand? Have you got an estimate of what it is that's being claimed? Is there something that this is based upon? And I didn't get it until January 7th, and when we, within, say, 8 days, invoked appraisal. That's
So if you look to our cases that you brought to our attention in Norton and Wooden, they stand for the proposition when the complaint is vague and you need more information, that a motion for a more definite statement would be appropriate in those circumstances, and certainly it's not inconsistent with the right to appraisal. Do you disagree that that would have been an appropriate tool to use here and would not have amounted to a responsive pleading?
First off, I think it's the Wooten case, not Norton, came out of the 14th Circuit, which is one of the circuits we practice in Panama City. And there had already been ruling. In fact, that was one of the rulings that we knew about, where the trial judge at that time and the trial judges were saying, you file a motion for a more definite statement and you have waived appraisal. That's what they were saying. We didn't know that the court was going to say that's not a waiver of appraisal. So that's one of the reasons we didn't file it. Number two was, I'm sort of an advocate, an old-time advocate of Professor Trawick, who says the motion for a more definite statement is a useless anachronism, that under our rules of pleading, for simple statements of pleadings and the case law which interprets it, that the complaint must be, and all facts well pled in the complaint must be accepted as true on the face value, and any motion to dismiss must be based upon the four corners of the complaint, that a motion for a more definite statement is just pointless. You can respond to any complaint by saying you either admit it, you deny it, or we can't admit or deny it because you don't give enough information. So I've sort of been an advocate of his, and he, in his treatise, says that it's not a appropriate motion to ever be made. So that's one of the reasons, and plus, of course, the lower courts at that time had been ruling that was a waiver of appraisal.
Counsel, could you address the argument that, for example, interrogatory 5 and 6, which were filed in November, the responses to those, to me, don't seem to indicate that there's any coverage issue whatsoever, that it's strictly a damages type dispute. Could you respond to that?
Yes, that we agree. That it was, at that time, we determined it was damages only, and here's what we paid for damages. Not a coverage dispute, no, but a dispute as to whether or not you understood, we've already paid this claim. We paid damages.
Right, and I appreciate that concession. So then why are we waiting till mid-January to ask for the appraisal?
We didn't know that there was amount in dispute, remember? They had never given us any indication there was any dispute
Doesn't the
whatsoever,
filing of the complaint
other until filing a
sort of
complaint.
indicate that we dispute, that you haven't paid us enough?
Maybe they didn't realize they'd been paid. I mean, how was I supposed to know? We hadn't gotten any information before. There'd never been any kind of pre-suit notice, notice of intent to initiate litigation, anything.
Why not include it in your affirmative defenses at least?
Probably should have, although I'm not sure, most of the appellate courts aren't too thrilled about affirmative defenses, as you know, and they don't generally support them, so we don't try to over-inundate pleadings. Plus, of course, are we supposed to not initiate litigation? Or are we supposed to, try to get to the appraisal stage as quickly as possible, if it is appropriate for appraisal, which we didn't know until January?
What was it about January? What was the specific piece of information that in your mind? That was
Estimate came from a counsel January 7th in the confidential settlements demand that says this is what we're claiming and this is what the dispute is about. And that's the first time we knew about it. And that's undisputed, and it's admitted, by the way, in the transcript, by the way, that was referred to by opposing counsel. I'd only refresh the courts to one thing, and that is the leading case on appraisal in general and waiver is, and I quoted in the brief, and that is the Florida Insurance Guarantee versus Morales case. Now, the question of waiver of appraisal is not solely about the length of time the case is pending or the number of filings the appraisal-seeking party has made. Instead, the primary focus is whether the party acted inconsistently with their appraisal rights. We don't feel we did under these circumstances. We didn't know about what was in dispute or that it was any dispute until January 7th, and we invoked appraisal within 8 days.
What would you acknowledge that there is a point on, if there's a time continuum from the filing of a suit to trial, at some point along that continuum, it would be too late, where the insurance company would be considered to have, I would call it forfeited, not waived, but forfeited its right to an appraisal. Where do you think that, where would you have us draw that line? Like, what would be the criteria that we should apply to determine how far the insurance company has gone where it's too far?
I think if we had filed discovery of our own, I think if we had filed motions of our own, I think if we had asked for depositions, then yes, that would be too much.
And what is it about those things
That's engaging.
that would be inconsistent with seeking an appraisal, whereas filing an answer and demanding a jury trial and producing discovery would not be?
Well, that would be the engaging in litigation. We didn't engage in litigation.
Well, it can't. So, and that's what I'm struggling with also. I mean, I know that these cases talk about it, but this idea of engaging in litigation derives from arbitration cases originally. And clearly appraisals and arbitration are different. And I can see where engaging in litigation is wholly inconsistent with seeking arbitration. Not necessarily the case with respect to appraisal, because an appraisal is determining, it's an alternative means of determining the loss amount, and you still have to bring it back into court. So it can't just be just engaging in litigation, which your client did actually in this case too. Presumably it's going to be more, and like even Bronco, it was the plaintiffs. I mean, they themselves filed suit, engaged in litigation for what, 2 or 3 years, and then decided on the eve of trial, we want an appraisal. That's probably at one end of the continuum. Where do we draw the line at the other end, where the insurance company will have gone too far versus not? And it can't just be engaged in litigation, because that would mean doing anything in response to a complaint would forfeit your right to an appraisal, right?
I agree. I think probably, looking at it logically, it would be, once you know what is in dispute, once you know what the damages are being claimed, if you don't invoke within a reasonable period of time appraisal at that point, yes, you waived it. Well, we didn't act inconsistently over an extended period of time. Within 8 days of finding out what the dispute was about and what the amount was, we invoked appraisal.
And is that a fact determination that the trial court's supposed to make?
I believe it would be if the facts were in dispute. Yes, it's a factual determination, sure.
And where does that leave us here, like in terms of the record and what what supports the determination that your client, as soon as it knew what was in dispute, it filed its
I
demand
didn't
for
think
appraisal?
that was in dispute factually. There's been, and you can see from the transcripts of the hearings that counsel on both sides stated that was the facts and they weren't disputed. I don't
Yes,
think
but
they are in
the
dispute.
grant of the motion was pretty much summarily granted. There was no discussion, citation to the 2 cases, but no explanation by the trial judge.
True. We have the transcript of the hearing, though, which is filed with the record, or filed with the appendix, excuse me, that shows where the counsel both argued that.
Put it a different way, who bears the burden of establishing that, I don't know, either that your client didn't forfeit or that your client appropriately claimed a right to an appraisal?
Well, I think the burden of proof would be, of course, on the party opposing appraisal, at least the burden of, and then the burden of going forward. Once they established prima facie case, then we would have the burden of proving that we didn't waive.
But aren't you seeking enforcement, essentially you're seeking an enforcement of a contract provision?
Correct. Yes, sir.
So wouldn't the burden be on the movant? Or you're saying
Burden
that
would
the
be on the movement to establish a prima facie case. Yes, we have the right to appraisal in the contract. Here it is. We have a notice. So we've done that.
and then the forfeiture as a defense would be on the
Would be
other
on-
side, is
yes.
what you're saying? Okay.
That'd be my opinion. And thank you, ladies and gentlemen.
Okay. Thank you, counsel. You may proceed.
I don't know if you would consider this a factual dispute, but counsel for Castle Key again states that they had no notice there was any dispute until the complaint was filed, which isn't correct. Again, if you look at those discovery responses, you will see that at least there was an amount in dispute or causation for the windows, which claimant had an estimate and they denied payment on. That's clear. Also, and while the letter is not in the record, the reference to our notice of representation that we filed with Castle Key on August 11th is in the record on page 73, and another letter that we write to Castle Key telling them why we're objecting to their basically their motion to invoke appraisal because it's untimely and waived. We refer to our letter of representation there, and then also in the transcript of the hearing, I refer to it on page 66. So we have facts underlying here where Castle Key never responded to that for 45 days. Florida statute requires them to respond within 30. So we never got a response. So what is the plaintiff to do if they're not getting a response from the insurance company but file a complaint? We know there's a dispute. Our client does. Castle Key should know because they denied coverage for the windows. Maybe they think that the claimant's just going to accept that, but it's not the case. And the long line of cases here clearly show that a case is ripe for appraisal when coverage has been acknowledged and the claim has been adjusted and payment made. The other side is conceding that. So we know that it's already ripe. It's not the issue of, was it ripe before or after litigation? It was ripe well before litigation, and it was never requested. Our case doesn't stand on that premise, but I just would like the court to know we have a 2-year period still where they haven't requested appraisal. Perhaps they did think the claimant went away. The plaintiff decided they weren't going to dispute the windows. I don't know. But certainly within a few months after that, we did our notice of representation and never got a response. So at that point, our only avenue was to file the complaint specifically for the amount of loss, for compensation. The cases we believe are clear that say that that right to appraisal, it's a contractual right, has to be safeguarded. And in order to safeguard that, it needs to be pled before you do anything inconsistent with it. There are several things that Castle Key did that were inconsistent throughout, and they knew there was a dispute in the complaint. They were able to intelligently respond to the complaint. One cannot argue that they did not, because they did. The rules of civil procedure provide that if something is so vague and ambiguous you can't figure out what is being claimed, you can file a motion for more definitive statement. While Trawick may disagree with that, that is the current rule. Those are the rules that the Florida Supreme Court has adopted. And that is the appropriate action to take, or in the first responsive pleading, an answer to bring up the fact that appraisal is appropriate here, either invoking it or bringing it up as an affirmative defense somewhere, and not requesting a jury trial, which was done here. Again, it's a red herring saying, well, we don't know what the amount was. That's the whole point for appraisal, because people don't know the amount. So request it so we can figure out. The very fact that Castle Key asked for a settlement demand shows they knew what was in dispute, the amount of loss. That alone shows that they knew that it was ripe for appraisal. They knew the amount of loss was at issue. And then there are cases where the plaintiff may not know exactly how much is at issue. An example is, as in this case, if you didn't have an invoice, our client did, but say the windows should have been covered, but you don't really know how much the windows are going to cost because they said it's not causally related. Well, that's when you ask for an appraisal. But it defies the case law that we have that's long-standing that says that a settlement demand must be given, or it's not ripe until after that because they don't know the specific amount. But going to amount, our complaint says it's more than $30,000, and then in the civil cover sheet, it's marked between $50,000 and $75,000. Okay, and that is in the record. So there are clearly amounts marked. And in the settlement letter that we sent, we don't ask for a specific amount. We just say, hey, here's what our expert did. Look at it, see what you think of the scope.
Do you agree with the assertion that the burden would be on your client to submit evidence of forfeiture if there were a need for that?
A forfeiture of their right to appraisal? Yes. Submit evidence on that?
Sure. I mean, isn't it sort of a mini evidentiary issue? So they're seeking to enforce a contractual provision. They raise it as by motion. You're claiming it should be denied because they forfeited it. Isn't that, and if it's an evidentiary question, don't you bear the burden of submitting evidence to show forfeiture?
I think that's fair when it does become an evidentiary question. Again, here I think the evidence is clear.
Which is what?
The evidence that's been waived. Well, that
just the pleadings.
Well, the pleadings and the discovery responses. If you're going to rely on the fact that they said they got a settlement demand, they didn't have an amount. That's in the record. They never responded to our letter of representation. How long are we supposed to wait for that? They usually have 30 days. We were well past 30 days by the time we filed suit.
Does it matter, though, that your client dumped not only the complaint, but a lot of discovery, typical, lengthy with definitions and instructions and everything else, the typical civil litigation discovery, dumped all of that on them at the same time? Does that matter that maybe they should respond first and then deal with the appraisal issue?
No, Your Honor, I feel the fact that they actually did respond matters because, again, that shows they are responding to the specific issue of amount of loss. They're submitting that to the court here, rather than just stopping and say, we think appraisal is appropriate at the point. At least let the court address it and the court make a ruling. As in Wooden or Norton, the lower court got it wrong, but the insurer was forced to go through some discovery, otherwise potentially subject itself to sanctions. But it had done a motion for more definitive statement, which is what this particular district has said is what is necessary if you're going to preserve that right, or at least claim that right as an affirmative defense or somewhere in your initial pleading. So again, I believe on the totality of the circumstances here, they have waived that right to appraisal. And again, this could have gone on for years. Maybe they didn't like where it was going, the court, and then it's almost changing horses, mid-race. It was ripe at the time we filed suit. Well before that, they should have at least claimed it because it was clear that we were claiming amount of loss was at issue. They understood it because they responded to that and even did affirmative defenses in regard to the amount of loss.
Thank you, counsel.
Thank you very much for your time.
Thank you, both attorneys. We appreciate your arguments today.
Thank you.
Again, welcome to the First District Court of Appeal. Our next and final case on the docket today is Dillard's Incorporated and Gallagher Bassett Services Incorporated versus Agatha Choi. Counsel for the appellants, you may proceed when you're ready.
Good morning, Your Honors. May it please the Court. Karen Cullen on behalf of Dillard's and Gallagher Bassett. I'd like to reserve 5 minutes for rebuttal.
Okay, so noted.
We're here today seeking a reversal of the JCC's decision below, denying my clients what is often referred to as fraud or misrepresentation defense based on sections 44009 and 44105, of the Florida statutes. By way of background, there's a stipulation for attendant care services that was entered into between the parties back in 2015. The claimant is to receive the checks. Her daughter...
And let me stop you right there, since this is going to be an important subject matter of some of my questions, and I'll ask Appellee's counsel to address them the same. The stipulation in 2015, was there an order entered approving that stipulation? I don't see the stip in the record. I looked at the docket. I can't determine from the docket, do we have an order, or do the parties agree that there was an order approving the stipulation?
The stipulation was before my time, Judge, but I did look at that issue this morning. It's named an agreed stipulation and order, but I don't see an order in the record. And so I don't know the answer to that question. I just see the stipulation. I don't see an order on the stipulation in the record.
Right, because both of you may have anticipated this, question coming, but, it struck me as soon as I started reviewing the case that because we have a stipulation most often approved by order, why didn't this proceed on a 440-28 track as opposed to just the normal claim process under 44019, because you've got totally different standards and you've got a jurisdictional issue. In looking through the record and reading every word, I see the first time that modification comes up is in the claimant's response to the motion for rehearing, and then I see it in one paragraph in the answer brief. I don't see it mentioned at the hearing or at, any other point than those two. So can you address why should we have a concern that we've got a jurisdictional issue that this should have proceeded under 44028?
It did not come up at trial, Judge. Nobody argued that this should have been a motion for modification versus a fraud defense. Those are two very different issues in my mind. I had an attendant care case one time where the care provider was the husband and he passed. And so there was an issue about, well, we need to modify that stipulation because the caregiver isn't around anymore. We need to make different arrangements, and that needs to be agreed to between the parties. That's different from a case here where we're talking about a misrepresentation. So that's why the case proceeded under those statutory
Right, but we're
sections.
still affecting an order that says you are to pay attendant care benefits, and through my years of comp in the case law, it says a carrier cannot unilaterally discontinue benefits that are ordered unless they go through and say, motion for modification, judge, here's the change of condition, mistake of fact, allow us to discontinue the benefit. So I guess, do we have a jurisdictional concern here, or in your opinion, do we ignore it or proceed?
I don't think we have an issue here. It wasn't raised below. The claimant never argued that our defense was barred because this should be proceeding under a modification rule as opposed to under the fraud, and I do think the fraud trumps the issue.
Right, well, we've got
and I don't see an order in the record.
Right, we've got a fantastic opinion, a recent opinion from Judge Nordby of our court addressing whether you can address sort of sua sponte, a jurisdictional issue not contemplated below, and her ultimate decision and approved by the majority was that we can, as a matter of first impression, address jurisdictional issues. So in your opinion, there may be a different school of thought there. In your opinion, can we do that or should we do that?
I think you have jurisdiction. It wasn't raised, the modification wasn't raised below, and I don't see an order that we're working off of. I see what's called an agreed stipulation without any reference to an order in the record. Again, before my time, Judge, so
Right.
I can't really speak to that, but it's not in this record.
Thank you.
Thank you. So going back to provide some of the facts, we're working off this stipulation.
And I think, and I'm sorry to
That's okay.
interrupt, but we are well familiar with the facts. And so my question for you on the facts are, what significance, if any, should we give to the fact that the claimant's daughter is the one who had made the alleged misrepresentations, and the claimant had testified that she never reviewed the forms? And to the extent there could be a conspiracy there that I believe was raised for the first time on appeal and not below. So could you help us understand what significance, if any, we should attribute to those facts?
Okay. Well, the conspiracy issue, it's the fourth subparagraph of that section, and it was pled. It was in my trial memo. So it wasn't raised for the first time on appeal. But the issue does involve what misrepresentations are made by the claimant. And I think everybody got caught up on these logs and the timing and whether or not the claimant reviewed the logs. The claimant provided testimony as to what care she received, irrespective of the logs. She provided that testimony in her deposition, and she provided that testimony again at trial. And those statements, when you look at the logs and when you look at the time records from the daughter's employer, are inaccurate. She could not have received the care that she's claiming that she received based on the fact that the daughter wasn't there to provide it. Specifically, and this is again, not talking about the specific logs. She's asked about what care she receives. And she says in her deposition testimony, first, she says, my daughter only works the day shift. We know that's not accurate. She started working the night shift in March of 2020. She says she comes home every night around dinner time to provide care. She's there every night to cook, prepare, or bring dinner home. That's pages 145, 146, and 173 of the record. She says she's there in the evenings to help her bathe. That's 175 of the record. She says they take walks around the neighborhood 5 to 6 times per night. It's mandatory, she says. That's page 176 of the record. At trial, she came in and again testified that her daughter helps her in the morning. She helps me get out of bed. She helps me do stretches. The claimant testified that she gets up at 6 in the morning. So that's an early morning activity that has to be completed. She says she applies ice packs, therapy, massage at night, right before bed. That is at 10 o'clock at night, according to the claimant. Again, walking around the neighborhood 5 to 6 times at night and helping with bathing at night. So her own testimony, irrespective of the logs, is that she received the care. She knows what care she receives, and she's receiving the check for the care that's supposed to have been provided. So that is where the misrepresentation, Judge, comes into play.
Wasn't there testimony also at the final hearing that those activities actually were provided? Maybe just not at exactly the right times, but that they were provided?
Yes, the daughter on, I think it was recross examination, for the first time we are told, oh, wait a minute, the logs aren't accurate. Both the claimant and the daughter were asked about the logs in their depositions. They were asked about the times referenced in there. And, you know, I think they even, counsel in questioning them said, I don't expect it to be exact, but can you tell me, you know, how rough, give me a rough estimate as to when this care is provided. The claimant testified within 10 to 30 minutes of what's listed on here. The daughter says within an hour. For the first time on recross at trial, the daughter says, wait, no, the logs are wrong. I've been using the same log since I worked day shifts, and I never changed it over when I started working night shifts. I did all this service, just not at the time listed on the logs. And 2 points I would make to that, Judge. First, the JCC says there's a simple explanation for all of this, and that's what it is. She still did the service, she just didn't update the logs. Well, if you look at the logs in January, in February, and March of 2020, before the night shift began, when she's using the logs that are supposedly the correct ones, the same issues are there. The same problem with she's not there, according to her time records, at the time that she's supposedly providing these services.
Right, but that goes back to the issue of the logs. And let's just assume for a moment, I mean, obviously there's an issue with the logs.
Mm-hmm.
But Judge Ray's question was with respect to the claimant herself. To what extent should she be held responsible? And it sounds like, so from her perspective, if she's getting these services or this care from her daughter, maybe she doesn't know exactly when it was. She just knows that it's being provided. And the daughter says it's being provided. And that's what the JCC hears. And the JCC determines, well, okay, the logs are off and that's probably the daughter's problem. But from the claimant's perspective, at best she testified to, I'm getting this stuff. And he chose to believe that. And chose not to hold her, the claimant, responsible for whatever sins her daughter committed in this.
Well, again, it's coming back to what care does the claimant say she's receiving?
Sure.
And does the record support that she could have received it? And my point is that when you look at the time records from the hospital, which are not in dispute, the care that the claimant says she received could not have been provided, irrespective of the time, though. It's not just about the time, Judge. If you look at the character of the activities, okay. So again, the time issue became an issue at trial when the daughter testified to the changing of the logs. But putting that aside, look at what the activities are that the claimant said she received. She helps me get up in the morning, which is around 6 a.m., to do stretches. That could not have been provided if the daughter's not there in the morning. Irrespective of what, I mean.
Unless she got up later.
Unless she got up much later, yeah. But her testimony was, I get up very early. I get up at 6 in the morning. And so certain activities on here are not subject to manipulation by time, I guess is my point. Again, ice packs, therapy, massage at night before bed. When the daughter is working those back-to-back night shifts at the hospital, she's not there for bedtime. She's gone and she's gone all night. So she's not able to do the ice packs, the therapy, the massage at night. She's not able to walk around the neighborhood that's supposed to happen 5 to 6 times a night. And she's not able to help her with bathing. So my point is, even if you want to move the times around, forget about the times. These activities are such that they could not have been provided when the claimant says they were. So that is the point about the misrepresentation. Back to my first point on appeal is that the judge applied he didn't follow the standard for misrepresentation. He seems to suggest that these statements could not have been made for the purpose of securing benefits because she was already receiving them. And there's no basis for that in the law. There's no basis for that in the case law. Many fraud cases arise while somebody is already receiving benefits. You could have a permanently and totally disabled claimant that starts working and doesn't tell the truth about that, and a fraud defense would arise. So our position is that he erred as a matter of law in applying the analysis as to whether or not a misrepresentation was made. And then the second point, Your Honors, is that even if, alternatively, that competent substantial evidence does not support the findings that he made because those time records established that this care could not have been received. The daughter was working 15-hour days, according to her testimony, sleeping for 5 hours of the day, and then supposedly providing this care for the other 4 hours of the day, which simply was not possible when you look at the time records. There's 118 days in 2020 alone where it was not physically possible for the care that was alleged to have been provided to have been received based on the daughter's schedule.
Just based on those laws, I mean, it is possible, though, that the care was provided at some other time in the day.
It's possible that some care could have been provided in that small little window, yes, but the specific services, and it's important to note that the judge seemed to suggest that, she provided more than 2.5 hours even. She provided 4.5 hours on some of these logs on occasion. Well, a lot of this stuff on the logs isn't necessarily reimbursable attendant care. I mean, she's writing a lot of stuff on this log that she may or may not, be covered for. So just because she puts it on here doesn't mean she's getting paid for it. She gets paid for 2.5 hours a day. She's a family member, so anything that's normal, gratuitous type service that a family member would provide would not be included. And I think in finding that she did all this care, the judge failed to acknowledge that point as well.
But that would go to overpayment.
That would go
The
to that.
overpayment issue.
That would go to that issue. Yeah, I think so. And that's our third point on appeal, which is that if we shouldn't be obligated to pay for care that isn't provided. And again, the logs establish that there's no way that this care could have been provided. 118 days in 2020 alone. And the explanation given at trial by the daughter, when you look at the specific services that are alleged to have been provided, doesn't explain that away.
But there's two components to the overpayment argument. One is we overpaid because the services weren't provided, and the other part is we paid for services that are gratuitous from a family member.
It's really that we shouldn't have had to pay for services that weren't provided.
Okay.
The gratuitous thing I think goes a lot to the judge's, she provided all this care, and there's no evidence that was reimbursable care.
So that aspect's not really part of your...
It's more
case
that
here.
we shouldn't have to go, it's relevant to the argument, I think, Judge. I don't know that it's a separate point,
Right.
but it goes to the finding of the judge that all this care had been provided. Well, certain parts of that care aren't reimbursable.
In other words, you're not saying that the judge erred by not going piece by piece and determining which services, on the logs at least, were gratuitous family member care.
Correct.
It's just based on, if you're not going to cut her off completely, at least get paid back for the stuff that...
Yeah, we're not obligated to provide care that wasn't received, and the time records show that was the case for at least 118 days in 2020 alone.
And how would that work? Like, how could the judge, to take your position, your view, to get to that third point, the overpayment aspect, how could the judge get there and not determine that there was misrepresentations here?
Well, that's an interesting question. I'm not so sure. I
I
don't
mean,
know.
is it possible to have that claim as overpayment? Does that relieve you of some sort of burden?
Well, I think there are two different issues. I mean, he could make the finding that there wasn't misrepresentation, but still the care wasn't received. And so you shouldn't have to pay for care that wasn't provided. So,
Or that it wasn't intentional and knowingly.
right.
Okay.
I see that I am well into my rebuttal time, so unless you have any other questions, I'll sit down.
Thank you,
Thank
counsel.
you.
Thank you. May it please the court. My name is John Ram, and I, along with Amy DeGuzman, represent the appellee Agatha Cho. We request this court affirm the judge of compensation case decision below denying the fraud defense. This court should affirm because Judge Humphrey correctly applied the law, and there is competent, substantial evidence to support his decision.
Could you address my modification concern?
The jurisdiction concern?
Correct, that, why wasn't this litigated under 44028? And the rule says the judge sua sponte could have recognized it or at request of either party. So do we have a step in order that would require this to have gone through modification? You addressed it, I think, for the first time in your response to
Yes.
the motion for rehearing and then short paragraph in your answer brief. So can you talk to us about that?
Yes, ma'am. We addressed it in our response because that was the first time it had been raised in an argument. And at trial, we really weren't sure what fraud was that was being argued. I do think that's the way they should have proceeded, was through a 44028 modification if they had a problem with the attended care provider.
Well, and if that's the case, if we determine, and we've had a recent case, I say recent, in 2018, this court in Hackett addressed a very similar issue and said that the 44028 issue is jurisdictional. So if we were to find that there wasn't jurisdiction to address this under a normal 44019 trial process, is this a tipsy coachman type situation, or are we required to remand to the JCC and say this should proceed under 44028 and that applicable standard?
Your Honor, it would be the tipsy coachman situation, and the reason being is the judge made the appropriate findings to support his order with regard to the fraud, which would not be under the 44028, and he made appropriate findings with regard to the attendant care being provided that there would be no reason to remand it.
Well, how would you differentiate the two, I guess, applicable standards? So you've got knowing and intentional
Yes, ma'am.
applied to misrepresentation the way it was litigated. If it goes back under 44028, the standard is change of circumstances or mistake of fact, which arguably would be a lesser burden of proof than the knowing and intentional under misrepresentation. So recognizing those different standards, could you tipsy coachman, analysis this and say, sort of, us to analyze the situation where does this have to go back or not?
This does not have to go back, Your Honor. The judge made more than adequate findings about each point raised by the appellant on their argument. He made findings, and the findings are supported by evidence. There's no need for it to go back for him to make any more findings. They'd be the same.
Did you represent the claimant, the entirety of the claim?
No, ma'am. I took over in 2015 or 2016, somewhere in that range, right after the STIP had already been put in place.
Okay, so do you have any input with respect to the record? I'm not asking for us to make assumptions, but in terms of, is there an order on the STIP?
I thought there was an order, and I thought there was the STIP filed, and I remember telling the judge the record number because I'm the one that requested he take judicial notice of it. There are two Ms. Cho cases. I don't know why, honestly, it's not in the record. It should be. But it was 2.5 hours a day. The judge talked about in detail. He clearly had it and had reviewed it. I wish I had a better answer for you on where it is.
Thank you.
I want to first talk about the standard of review, if I may. The correct standard, I believe, in this case is whether competent substantial evidence exists to support the decision below. We've talked for most of the appellant's argument and mine so far about facts, and that's the CSA part. But the first part is what they have alleged is how the judge applied the law wrong. And I have not heard yet how the prong 1 has been applied wrong, and I've heard very little about how prong 2 was applied wrong. I think the judge did follow the correct law. He followed the Markham case, and that required him to make a determination if she made a false statement, number 1, and number 2, if that false statement she made with the intent to deceive or mislead the court to secure benefits. The judge spent a great deal of time going over these prongs, and he found, and it's undisputed, that he found that she did not intend to make a false statement. First of all, so for the first part, she did not intend to make a false statement, and so the test would then be, did she make a statement that she intended to deceive? I don't think she could have if she didn't make a false statement. And so that's the first part. The claimant did not make any false statement according to the facts from the fact finder. And therefore, the only thing this court really can review.
Didn't the evidence, what do you say to your opposing counsel that pointed out, I think at length, there are a variety of days when what your client said happened could not have happened?
Well, let me approach that this way, Your Honor. The judge of compensation heard the testimony from the attendant care provider. He heard the testimony from Ms. Cho. He cross-examination at the end of the trial. No one ever asked her that. And she's explained why. She said, these forms don't reflect what I did on those days, at those times. They reflect what I do in general, and I just cut and paste. And I was working as an ER nurse. I'm working 12 to 14-hour shifts. And when I come home, I'm exhausted. I get only 4 hours sleep, and I just cut and paste. And what's important about all that is the trier of fact got to evaluate her credibility, her demeanor. He thought she was very credible and believable, and he accepted her testimony as that being the fact. So,
right, but that testimony was, yeah, I falsified forms. I didn't tell the truth on a log, and I did it many times. And so the JCC says, yeah, I find that credible. I find her explanation credible, but the fact remains that the evidence shows, based on her admission, that she didn't tell the truth in those forms. Now, that's her. She's not the claimant.
Exactly.
So, let's go back then to what the claimant said, what your client said, both in the deposition and then on the proverbial stand. She continues to say, all these, at least at deposition, she said these services were provided. And if you piece it all together, where's the wiggle room where the JCC could say, yeah, I believe that there's a possibility that what she said in deposition was true.
He found it was true what she said at deposition. There's
notwithstanding the contradictory, where's the explanation as to how that was possible? Like that her daughter was providing services on these particular days when she couldn't have, including my daughter doesn't work the night shift. Can you just address that?
Well, Judge, it's important to look at the law before I address that. She has to have a knowing and intentional intent to deceive.
Knowing or an intention.
Or intentional, either one.
Yeah.
Okay? So that's the claimant. That's not the attendant care provider. The judge found she did not have that. This court has held in Pinnacle versus Albee that it is the trier of the fact that makes these determinations. In Albee, the judge in Albee looked at the candor, demeanor, and evaluated the witness's credibility. And he made a fact finding, and this court does not disturb and retry the case at the appellate level. They accept what the fact finder finds unless there is no CSE to support it. In this case, I'll start with the deposition. Ms. Cho had not seen the forms before. She did not look at them, all the forms. She looked at about 5 days worth of forms. She was not asked about specific days, because then when they asked her, what did you do do you remember July 16th? She said, no, I don't. She was asked if this means AM, this means PM. This was an update deposition. She wasn't sure why she was there. There was no pending petition. She was getting her permanent total. She was getting her injection. She was seeing her doctor, and she was getting the attendant care. So you also have to take into account that she is a 65-year-old Korean-born lady. English is her second language. She speaks pretty good English, but sometimes she gets confused, and she testified to that. Sometimes she doesn't think as well as she should. She was shown these forms, these 5 days of these 100 and however many it was, and wasn't asked specifically on this date, well, if this says you were put to bed on this day at this time, is that accurate? That's not how it was. It was, well, what does that mean? How does this happen? What time is that? Is that PM? Is that AM? Is it always that way? Is it within 5 to 10 minutes? And then at the end, well, looking at these forms, did they appear to be accurate to you? And her answer was, yes, they do. And she said, well, my daughter prepared them. They must be accurate. She testified at trial that she did not see the times on the forms when she was asked about them. And at trial, when she was asked about them again, after she was asked about whether she had testified that they were accurate, she said, she stopped, and the next question for her was, accurate? Well, accurate means done well, correct? As she clearly did not understand the whole implication was going on. So she hadn't seen these forms. She didn't prepare them. She wasn't involved in submitting them. She asked during the deposition, when they asked her about these forms being submitted, she asked, am I supposed to submit them? And she didn't know. The judge found that there had been no instruction on how these forms were supposed to be done from the carrier to either one of them. So the judge took that testimony, and then he took the trial testimony. You have someone that's asked if a handful of forms are accurate, you page through them quickly, and you're not asked questions about specific dates or specific times. Absolutely, there's what you would call wiggle room there, because the judge accepted that she didn't know what was on the forms, that she wasn't misrepresenting to the court what was on the forms. She made an inaccurate statement about her daughter and niece, but inaccurate has been held by this court not to be, this court held it, Markham as axiomatic. That does not mean someone who gives a false statement automatically is disqualified for benefits. In fact, that same case in Markham held that a criminal situation, like in the Markham case, was a false Social Security number. I'm sorry, that was the Hernandez case, First Matrix Policing. That a criminal situation where someone gave a false number, a false Social Security card to get a job, which was a criminal offense, was not enough and did not automatically mean that, hey, your benefits are forfeit. This court has to realize that we are talking about the ultimate situation where all benefits are cut off. No more PTD, no more attendant care, no more medical treatment, no more supervision and assistance of doctors. That's why the knowing and intentional, the subjective intent is so important. And that's not for y'all to retry when we look at all these logs. That was decided by the trial judge. We just look to see if there is evidence to support his decision. And in this case, the attendant care provider testified at trial, and he accepted as fact, I provided her 2.5 hours a day, every day, even more than that. Yes, these forms, ignore these forms, but I provided that service every day. The attendant care, the claimant testified, yes, my daughter was always with me. She provides that, and she provides more every day. The judge accepted that as fact. And what we're asking, what the appellant is asking you to do is to ignore everything the judge found and reach a different conclusion, to have a new trial here, basically, of, well, all these logs had inaccuracies. Well, yes, the judge knew about that. He accepted the reason why it had inaccuracies. He said, look, this lady's exhausted. She's finding as a nurse as much as she can. She gets very little sleep. She's just cutting and pasting. Yes, she did the forms wrong, but that doesn't tether to the claimant. The claimant didn't have anything to do with that. Her fraud or false statements of the attendant care don't translate directly to the claimant.
Is there a mechanism by which the carrier could have gone after the daughter to seek, the money
Absolutely.
goes to the daughter and she's admitted that she's not done a great job with the forms, with the logs. Is there a mechanism by which the carrier should have gone after the daughter
There's several.
instead of the claimant?
They could have filed a motion to modify the attendant care agreement based on the daughter committing fraud. They could have turned it over to the state attorneys. They could have, at her deposition, asked her, hey, how are you doing this? We have surveillance showing you're not there. How are you doing these forms? They didn't ask her that. Could have confronted her, like in many of these fraud cases, there's a confrontation and an admission of misrepresentation. And then they could have turned that over to the state attorneys who could have criminally prosecuted her. They could have done all those things, but they didn't.
So is it your position that if the daughter, as a provider that's getting the payments ultimately from the carrier,
Yes.
if the provider is sort of the wrongdoer, that your client shouldn't be held responsible for that unless your client had something to do with it? Is that?
Absolutely. If this had been coming in from nurse service or granny nannies or some other type of service, no one would have questioned whether the judge wouldn't have had jurisdiction in that case, frankly. It would have been through the administration, ACA process. They would have filed something against the service provider for providing fraudulent forms, or they would have talked to them, or they would have simply changed providers.
More like a restitution kind of.
Yeah, and they could probably sue them in small claims court for restitution if the services weren't provided. It's important, Judge Tannenbaum, that to remember, though, that Judge Humphreys evaluated the testimony and decided that the services were all actually provided, just not at the times on the forms. It was all provided. It's not like services were not done. It's just different services or other services were done during different times of the day when she was home. It would have been nice if someone had said, hey, Miss Attendant Care Provider, how could you possibly have tucked her in that bed that night? You went to work at 7. And I suspect, based on her testimony at trial, she would have said the same thing she said at trial. Oh, I didn't. I cut and paste these forms. I did other stuff earlier in the day, and she probably could have listed what other stuff she'd done. She was very clear that she was exhausted doing these forms. You got to remember, when these forms started, it was 8 years ago in 2014. She was a young girl. She wasn't even in nursing school. She was home and taking care of her mom. She since went to nursing school, and now she's out working as a nurse in I think it's the cardiac ER. So and we also need to take into account, this was during the terrible COVID time when everybody was home except nurses and doctors and a few other essential providers. She was working her butt off.
But she was also still taking the checks and under
Yes.
the terms of the stipulation, which
Yes,
said
and
she
let's
needs
talk
to
about
provide
those
logs.
checks.
Yeah.
The checks were for $8.05 an hour for 2.5 hours a day. You're talking about $140 a week. It's not very much money at all. And most of the days, nurses don't work 5 days, 6 days, 7 days in a row. They work a day, 12, 14 hours, off another day. A lot of the times on those forms, if you want to compare the forms which have already been admitted and accepted that they were not accurate, they sometimes, more times, match up than not. And that's something else Judge Humphreys found in his order, that most of the service was provided if you just took it at its face. There are times when clearly it couldn't have been provided at that time, which was accepted by the trier of fact as a fact. And that'll bring me back to why I think we need to, there's no reason to go back for redetermination or evaluation for an overpayment. This court has held that in Exo Communications versus Mitchell, that the trier of fact is free to accept the testimony and the evidence that he picks and chooses. That's his job. It's not something that's going to be retried later. And Judge Humphreys, in this case, took a lot of testimony from each of the witnesses. There was no other evidence in there to contradict what they testified to. And the witnesses said, we provided 2.5 hours, if not more, every single day. The judge accepted that as a fact. And he even put it in his order that, 2.5 hours at a minimum was provided every day, because this is a young lady who is the attendant care provider, but she lives with her mom, and she works, and she comes home, and she takes care of her mom. Whatever it might be, that's what she's doing. And for these reasons, the JCC correctly applied the law, and because there's ample CSE to support the judge's factual findings, we feel this court should affirm and allow Mrs. Cho's benefits, her permanent total, her attendant care, and her medical treatment to be reinstated. Thank you very much.
Thank you, counsel. Went a little too far there. Okay. Let me make a point with a couple of the logs that I think will address the argument that I was raising about the time, Judge Tannenbaum specifically, that you were asking me about. If you look at the log from July the 17th, it's page 701 of the record. There's 4 entries on there. 5 o'clock in the morning to 5:20, helped get out of bed and stretch legs. 5:30 to 6, prepared breakfast and lunch. 8:30 to 9:25, this is PM now, cooked dinner, washed dishes. And from 9:35 to 10:30, applied ice packs, performed exercises, and massage therapy. She was working a back-to-back night shift, so she did not get home from the shift the night before, the daughter, until 8:22 in the morning. She then left again by 6:18 that afternoon. The character of the activities are such that even if you want to give her the benefit of the doubt that she did the 2 middle ones, preparing breakfast and lunch, cooking dinner, and washing dishes, she couldn't have done the first item and she couldn't have done the last item, which is well under the 2.5 hours that she's getting paid for. That's the point I'm trying to make, that it's about the character of the service. You can't get caught up in the timing of the logs, although both of these ladies were asked about the logs, and they were asked if they were accurate, and they were given an opportunity to explain. We didn't have the timesheets at the time of their depositions, but we had the logs, and they were asked if they were accurate. And they both said, yes, within 10 to 30 minutes, according to the claimant, and within an hour, according to the daughter. She was asked whether these logs were accurate. She didn't claim to be confused by them at the time of her deposition, and then she presented a completely different story at trial.
Right, but isn't the JCC entitled to sit there and watch the claimant testify and explain this and kind of say, okay, there's no way that this woman knows whether on July 17th all that was provided. It sounds right to her, presumably. What she knows is what she knows, what she experiences, and she knows most of the time, if not all the time, her daughter is there at some point providing some care. And why can't the JCC accept that conceptually and say, I'm not going to pull all her benefits because she doesn't remember whether her daughter was actually there on July 17th at that time?
I think it's more than that. It's not just whether she was there on July 17th. I wouldn't disagree with you that she's not supposed to remember an exact date. But she said, I'm receiving these services, these specific activities for which she receives a check. I receive these services and I receive them every day. That was her deposition testimony, and that was her trial testimony. So I think the judge got caught up in this whole timing thing, and that's what I'm trying to explain by talking about these logs is forget about the time, talk about what the service was, and could the service have been provided when this woman was working back-to-back night shifts in the middle of a pandemic and had no time. She wasn't there. And then if you look back, I'm sorry.
No, before you sit down, because you're running out of time,
Yes.
I did want you to address, and this maybe comes full circle, is your client authorized to just pull all benefits first without going to a JCC and having this determined? The way that I read the statute, it sounds like the JCC needs to make a determination first.
No, they're authorized to terminate benefits if they determine that fraud has been made, and then the issue comes about, as it did in this case, by way of a petition. When we stopped paying the attendant care and terminated the other benefits, they filed the petition, which is what brought us here today.
But even in the presence of an order.
I don't know that there's an order.
Well, I mean, let's just say generally speaking, we have a question mark here, but generally speaking, a carrier is not allowed by statute to unilaterally terminate benefits that are ordered per order.
If there was an order.
You would have to say, client, employer, carrier, I agree, we've got an issue here, I'm filing a modification. You must continue benefits until that order is rescinded.
And nobody challenged the way that this procedurally
But I mean,
transpired.
generally
below.
speaking.
Generally speaking,
Okay.
I would agree.
Well,
with
and we do know, I mean, there is an order for the disability. I mean, just holding aside the attendant care,
I don't know that there's an order for the disability or whether they administratively accepted her. That could have happened, Judge. I don't know that this was actually a trial for PTD, again, well before my time. But they may have just administratively accepted her as permanently and totally disabled. I think that might be what happened.
and who has the burden of establishing that in the first place?
Who has the burden of establishing?
Well, whether there's someone has to come forward first and establish, like, what is the basis? Why are we even in front of a JCC in the first place? So if there's no order, let's say it was all administrative in the first place, does someone have the burden to raise that? Does the claimant have to go in and say, hey, they cut off my benefits, we administratively agree to this in the first place, and there is no order, as opposed to your client having to raise it as going in and
It could-
explaining what the circumstances are.
I'm not sure I'm following your
Well,
question.
jurisdictionally, it goes back to we really are where we started. Like,
Right, we're having
on
a
the jurisdiction
great
side of it.
conversation.
Yeah, on the jurisdiction side, who
Right.
has the burden of pointing this out in the first place? And
I think
can
that-
we address it here now as an issue?
I mean, arguably, when my client stopped paying the benefits, the claimant could have raised that point, that you can't, per this order, do what you're doing. And that didn't happen.
Right, and then I think you've also got the issue of, in the absence of an order, if there was a stipulation or an administrative acceptance of PT in the attendant care, if they paid more than 120 days, then you've got a potential 120-day argument that could have come. So, I mean, there's a lot of factors that go into that pot, which is what concerns me about this jurisdictional issue.
Yeah, I don't think that the 120-day would have applied in a fraud context. I think that,
Well, I'm talking about in terms
But-
of being able to unilaterally cut off the benefits, or it's another defense you could unilaterally cut off under that.
Sure.
And argue that, but I think in answer to Judge Tannenbaum's question about can you do that, there's a lot of other factors that go into the pot that would have shifted burdens of proof somewhat.
I see that I'm out of time. Thank you all for your time, and we respectfully request that you reverse the decision below.
Thank you.
Thank you.
Thank you. Thank you to both attorneys for your presentations today. The court is now adjourned.
All rise.